I've been informed by the whippery that has agreed that there will be no notice of motion or motion without notice. The Secretary will read the first order of the day.
Consideration of report of Select Committee on Trade and International Relations, protocol amending the Marrakesh Agreement establishing the World Trade Organization, WTO, including Annexure 1A on the Agreement on Trade Facilitation.
Akbar Makoa.
Honorable Chairperson and honorable members, for our children in the gallery, welcome. Africa is our beginning, and Africa shall be our ending. May the celebration of Africa Day invoke renewed commitment, determination, and vigor for all of us to create a better Africa and a better world. My input is on the Marrakesh Agreement. But I want to quote the words of one of Africa's greatest leaders, the Chief Albert Luthuli, when he received the Nobel Peace Prize on the 11th of December, 1961. And our Honorable Chief said, "This award could not be for me alone, but it can also not be just for South Africa as a whole. Africa, the continent, presently is most deeply torn with strife and most bitterly stricken racial conflict." This was in 1971. How strange then it is that a man of Africa should be here to receive an award given for service to the cause of peace and brotherhood between men. I'm sure Ntata Luthuli would not mind if I add the sisterhood and the peace between us all. The Marrakesh Agreement and its Annex 1A is intended to deal with an agreement on trade facilitation and what is referred to as the ATF. This matter was for the first time raised in Singapore at the Ministerial Conference in 1996. Then in July 2004, a mandate to clarify and improve the General Agreement on Tariffs and Trade, what is also called a GATT, Article 5 for freedom of transit, Article 8 for fees and formalities connected with importation and exportation, and Article 10, the publication and administration of trade regulations was discussed. This agreement also aimed at enhancing technical assistance and capacity building in the area of trade facilitation to improve effective cooperation between customs and other appropriate authorities on trade facilitation and customs compliance. The provisions of the TFA in terms of GATT is to ensure transparency and appeals. In terms of GATT Article 8 for the import, export, transit, and fees formalities, and in terms of GATT Article 5 for the issue of transit. The agreement also has three categories. Category A is commitments that a developing country and a least developed country member designates for implementation upon entry into force of the TFA, or in the case of the LCD, within 1 year after entry into force. Category B relates to commitments that developing country member or LDC member designates for implementation on a date after the transitional period of time after the entry into force of the TFA, and that can be 1 to 5 years. And then category C relates to commitment that a developing country member or least developed country member designates for implementation on a date after a transitional period of time following the entry into force of the TFA and requiring the acquisition of implementation capacity through the provision of assistance and support for capacity building. Early warning mechanisms have been considered. If a developing country or a least developed country considers itself to experience difficulties to implement its commitments by the definitive dates it has notified, it should notify the TF committee. Developing countries must do this no later than 120 days before expiration, while least developed countries must do it at least 90 days before such date. Chairperson, it's important that we recognize that this is a very technical agreement of the WTO, but it is an important one. The WTO, the World Trade Organization, also looked at a grace period and dispute resolution, and it has formed a dispute resolution unit. Members can, however, resort to the dispute resolution unit to settle disputes against developing countries and least developing countries. Developing countries in category A has 2 years for that. Developing countries in category least developed countries in category A has 6 years, and least developing countries in category B and C has 8 years to do that. The time frames leading to implementation of the TFA is what is important. The TFA concluded in Bali in 2013. The drafting of protocol and amendments to the Marrakesh Agreement to include the TFA were handled. The WTO General Council adopted a protocol in November 2014 and opened this protocol for acceptance. The TFA entry into force, or will enter into force, when 2/3 of WTO members have ratified it. At the time of presentation, we were informed that the WTO has 108 members and 77 has already given notice of ratification. What does it mean for South Africa? South Africa emphasized that consideration must be given to the impact of the TFA on the regional integration processes in Africa and working on this in the African Union. We worked closely with the South African Customs Union, member states, in terms of coordinating our respective commitments. There is also an interdepartmental working group established, and this interdepartmental working group developed a list of South Africa Category A commitments, the terms of reference for establishment of a National Trade Facilitation Committee, and legal opinions were obtained from the Department of Justice, the Department of Constitutional Development, and the Department of International Cooperation and Relations. What is then the final point to us, Chair? The Cabinet approved the National Committee on Trade Facilitation to be co-chaired by the Department of Trade and Industry and the South African Revenue Services. The first meeting of the National Committee on the TF was held on the 6th of May, where it looked at South Africa's Category A commitments for submission to the World Trade Organization. Cabinet further approved that the protocol be submitted to Parliament for ratification. That means the National Assembly and the ONCOP. The protocol was accordingly approved by the National Assembly already in March 2016. And it is my pleasure and honor, on behalf of the Select Committee on Trade and International Relations, to present this Marrakesh Agreement, the protocol amending that agreement, establishing the WTO, including Annex A on the Agreement on Trade Facilitation to the NCOP for ratification. I thank you, Chairperson.
Thank you. Honorable members, allow me to acknowledge and welcome the future of our beloved country, the learners, the beautiful learners of Zimasa Primary School from Langa here in Western Cape. That concludes the debate. I shall now put the question. The question is that the report be agreed to. In accordance with Rule 7.1, I shall first allow provinces the opportunity to make their declaration of vote if they so wish. We shall now proceed to the voting on the question. I shall do this in an alphabetical order per province. Eastern Cape.
Thank you. Eastern Cape is voting in favor.
Free State.
Free State, yeah, Amoela, Chairperson.
Gauteng.
Gauteng agrees.
KwaZulu Natal.
KwaZulu Natal support, Chair.
Limpopo.
Limpopo supports.
Mpumalanga.
Mpumalanga supports.
Northern Cape.
Northern Cape agrees.
Northwest.
Province about Yabukuni Bupire Maya Dumel.
Western Cape.
Western Cape agrees.
Thank you. 9 provinces voted in favor. I therefore declare the report agreed to in terms of Section 65 of the Constitution. The Secretary will read the second order of the day.
Consideration of report of Select Committee on Cooperative Governance and Traditional Affairs, inspection in loco on notice of intervention issued in terms of Section 1391B of the Constitution, 1996 in Tabazimbi Local Municipality.
May invite the Chairperson of the Select Committee of Cooperative Governance and Traditional Affairs, Honorable Mohai.
Thank you very much, Honorable Chairperson, the Chief Whip, honorable members of the NCOP, our guests, learners who are the future leaders, as correctly said by Honorable Chairperson. Chair, the Provincial Executive Council of Limpopo has on the 17th of February 2016 considered the progress report of Tabazimbi on intervention in terms of Section 154 of the Constitution from August 2015 to January 2016. Chair, the Executive Council approved that Tabazimbi local municipality should be placed under Section 139, subsection 1B of the Constitution, and thereafter instructed that the MEC for COCTA should ensure that they assume the responsibility of the accounting officer on behalf of Tabazimbi local municipality in terms of Section 139, subsection 1B. Chair, the basis for invoking Section 139, subsection 1B of the Constitution, Tabazimbi local municipality started experiencing challenges around May 2015, and a rapid assessment team was established and constituted of officials from COCSTA, Provincial Treasury, and Salga Limpopo to provide fair, objective report on the state of affairs of the municipality. The task team focused on all key performance areas with specific recommendations for remedial actions or support required for the municipality. The task team observed the governance in the municipality was compromised. The financial health of the municipality has deteriorated since 2011-2012 financial year. Further, there were signs of inability by council to exercise its oversight role in the municipal affairs. There was also non-adherence to legislations and policies, for example, the SCM and human resource. The task team chair further observed the high number of litigations caused as a result of non-honoring financial commitments. The municipality was technically bankrupt and could not sustain itself, and the conditional grants was used for operational expenses. There was increased irregular expenditure from 73 million in 2011-2012 financial year to 209 million in 2012-2013 due to non-compliance with procurement processes. The Municipal Public Accounts Committee was not functional due to lack of support from management, and the municipality debt was around 320 million, which exceeded its own income. Chair, the administrator was appointed in the municipality and tasked with the preparation and implementation of the recovery plan. His responsibility was outlined in terms of the terms of reference. Chair, during the deliberations and views of the Select Committee, since the financial health of the municipality has deteriorated from 2011-2012, the Select Committee is of the opinion that sound financial management practices are essential to the long-term sustainability of the municipality. They underpin the process of democratic accountability. Weak financial management result in the misdirection of resources and increases the risk of corruption in the municipality. The provincial task team has also observed that good governance in the municipality was compromised. To ensure good governance as a Select Committee, we believe that the municipality should act as a focal point for and custodian of good governance. The council should play an active role in the strategic development process. It should ensure that the long-term strategy and IDP are aligned to the expectations and needs of members of the community and other stakeholders. Proper induction and skills development programs for councillors are essential to ensure effective execution of duties. Lack of adequate oversight by the political leadership in the municipality contributed in the lapse of financial and performance management disciplines. It is clear that practices that promote lean administration were not entrenched within the daily, weekly, and monthly activities of the municipality. Hence, they increased irregular expenditure from 73 million in 2011-2012 to 209 million in 2012-2013. Our recommendation stands as follows, Chairperson. As a Select Committee, we recommend that the NCOP approves the intervention in Tabazimbi local municipality in terms of Section 139, subsection 1B of the Constitution, that the MEC for Coxta and Salga in Limpopo province should spearhead a capacity building program for councillors and officials in Tabazimbi local municipality to address capacity challenges or constraints in the municipality. This capacity building program should be implemented within a month after adoption of this report. That the MEC for Coxta, together with the provincial treasury in Limpopo, should also conduct a workshop with the Tabazimbi local municipalities officials around compliance on issues of financial management. This should incorporate the compensation of employees, tariff structures, and supply chain management aspects. The Department of Coxta in Limpopo should table a progress report on the adjustment of salaries to be in line with the National Treasury guidelines in Tabazimbi local municipality. The progress report should be submitted to the NCOP within 30 days of the adoption of this report, and that the Department of Costa should table quarterly reports as well as the determination of intervention report on to the NCOP and the Limpopo Provincial Legislature. The determination of intervention report by the Department of Costa should include the forensic investigation report as approved by the Provincial Executive Council. And lastly, that the Select Committee on COCTA, after 2016 local government election, should facilitate a workshop on the constitutional, procedural, and substantive matters related to Section 139, Section 139 of the constitutional interventions with all municipalities in our country. This is what we recommend, Chairperson. I thank you.
Thank you. That concludes the debate. I shall now put the question. The question is that the report be agreed to. In accordance with Rule 7.1, I shall first allow provinces the opportunity to make their declaration of vote if they so wish. We shall now proceed to the voting on the question. I shall do this in alphabetical order per province. Eastern Cape.
Eastern Cape is voting in favor.
Free State.
Free State, amohela Chairperson.
Gauteng.
Gauteng agrees.
KwaZulu Natal.
KwaZulu Natal support, Chair.
Limpopo.
Limpopo votes in favor.
Mpumalanga.
Mpumalanga supports.
Northern Cape.
Northern Cape ya dumalatsana modulasetulo.
Northwest.
Bokoni bophirima ya dumela.
Western Cape.
Western Cape support.
Thank you. 9 provinces voted in favor. I therefore declare the report as agreed to in terms of Section 65 of the Constitution. The Secretary will read the third order of the day.
Consideration of report of Select Committee on Security and Justice, nomination of candidates to serve as representatives of the public on the National Council for Correctional Services as per Section 832H of the Correctional Services Act 111 of 1998.
I'll invite the chairperson of the Select Committee of Security and Justice, Honorable Quimby.
Thank you, Chairperson. Honorable members, Chief Whip of the Council. Chair, in terms of Section 83 of the Correctional Services Act 111 of 1998, the Minister must appoint a National Council for Correctional Services. The primary function of the NCCS is to advise the Minister in developing policy with regard to the correctional system and the sentencing process. Certain members of the NCCS also sit in the Correctional Supervision and Parole Review Board to review the decisions of the parole boards as and when referred. In the advert placed by the department in April 2016, the minister stated that he was particularly interested in identifying candidates with expertise in either one or more of the following fields, Chairperson. 1, representatives of the non-governmental organizations working within the field of correctional services. 2, experts in clinical psychology. 3, academics with expertise in criminal law, criminology, penology, or restorative justice, and experts in community justice system. Chairperson, members of the NCCS will be appointed for a period of 3 years. The Select Committee on Security and Justice, having considered a letter dated 25th April 2016 from the Minister of Justice and Correctional Services requesting the public on the requesting the consideration of the short list of the candidates to be appointed as representative of the public on the National Council for Correctional Services in terms of Section 83(2)H of the Correctional Service Act of 1998, Act number 111 of 1998, referred to candidates for consideration by the Minister of Justice, referred to it, recommends that the National Council of Provinces approved the following candidates for consideration by the Minister of Justice and Correctional Services to serve as representatives of the public on the National Council for Correctional Services. Category 1, Chairperson, experts in clinical psychology. 1, Mr. A.L. de Klerk. 2, Ms. T.S. Monyamane. 3, Ms. L.U.Z. Ratamane. Category 2, Chairperson, it's a representative of non-governmental organization working with the field of correctional services. 1 is Advocate K.A. Mahumani. 2, Reverend J.P. Clayton. Category 3, Chairperson. Category 3, yes. The academics with expertise in criminal law, criminology, penology, and restorative justice. 1 is Mr. A. Vilagazi. 2, Dr. V. Chetty. Category 4, Chairperson, expertise in community justice system. It's 1, Mr. M. Kope. Chairperson, the minister considered increasing that number of candidates with expertise in the community justice system. The Select Committee on Security and Justice reports that it has concluded its deliberations on the NCC candidates list and recommends that the National Council of Provinces approve the recommendation as approved. Thank you very much, Chairperson.
Thank you. That concludes the debate. I shall now put the question. The question is that the report be agreed to. In accordance with Rule 7.1, I shall first allow provinces the opportunity to make their declaration of vote if they so wish. We shall now proceed to the voting on the question. I shall do this in an alphabetical order per province. Eastern Cape,
Eastern Cape ayayixhasa le ngxelo.
Free State, Gauteng,
Gauteng agrees.
KwaZulu Natal,
KwaZulu-Natal ayeseka.
Limpopo,
Limpopo votes in favor.
Mpumalanga,
Impumalanga iyasekela sihlalo.
Northern Cape,
Northern Cape agrees, Chair.
Northwest,
Bokoni bophirima ya dumalana.
Western Cape.
Western Cape support.
Thank you. 9 provinces voted in favor. I therefore declare the report as agreed to in terms of Section 65 of the Constitution. The Secretary will read the 4th order of the day.
Consideration of report of Select Committee on Security and Justice, proclamations made in terms of Section 25 of the Protection of Constitutional Democracy Against Terrorists and Related Activities Act number 33 of 2004.
Honorable Qimbi.
Chairperson, thank you again. Chairperson, the United Nations has set up a sanctions committee which must list individuals and entities who are part of the link to Al-Qaeda and Taliban. The Protection of Constitutional Democracy Against Terrorists and Related Activities Act 2004 provides for enforcement of these sanctions. The notification by the President in respect of entities identified by the United Nations Security Council under Section 25 of the Proclamation of Constitutional Democracy Against Terrorists and Related Activities, Act number 33 of 2004, are legislatively...
Sorry. Can you take your seat? Honorable Mikalakis, why are you standing?
Thank you, Honourable House Chairperson. Just on a point of order, it seems that the member is busy with the 4th order and not the 3rd one of the day. He seems to have confused his speech for the 3rd order with the one with the 4th order. The 3rd order for the day is the Correctional Services Council. He's busy with the United Nations terrorism report. Just on a point of clarity, I'm not quite sure whether myself or him is confused.
No, I'll assist you. Now we are dealing with the 4th order. So the honorable member, the chairperson Qimbi, it's in order. So continue, Honorable Qimbi. We're dealing with the 4th order now, Honorable Mikalakis.
Thank you.
We're done with the 3rd order.
Thank you, Chairperson. As I said, that the notification by the President in respect of entities identified by United Nations Security Council under Section 25 of the Protection of Constitutional Democracy Against Terrorists and Related Activities Act of Act number 33 of 2004 are legislatively mandated through a government gazette proclamation. In the Protection of Constitutional Democracy Against Terrorists and Related Activities Act of 2004 provides for the following. Chairperson, to provide for measures to prevent and combat terrorists and related activities, to provide for an offense of terrorism and other offenses associated or connected with the terrorist activities, to provide for the convention offenses, to give effect to international instruments dealing with the terrorists and related activities, to provide for a mechanism to comply with the United Nations Security Council resolutions which are binding on member states in respect of terrorist and related activities. Also to provide for measures to prevent and combat the financing of terrorists and related activities, to provide investigative measures in respect of terrorists and related activities, and to provide for matters connected with aim. Chairperson, Section 26, Parliamentary Supervision. Every proclamation issued under Section 25 shall be tabled in Parliament for its consideration and decision, and Parliament may thereupon take such steps as it may consider necessary. The Select Committee on Security and Justice received a briefing on the proclamation made in terms of Section 25 of the Protection of Constitutional Democracy Against Terrorists and Related Activities, Act number 33 of 2004, tabled in Parliament on the 18th of November 2015 and 11th May 2016. In terms of the briefing, it has become imperative to ensure that Al-Qaeda and the Taliban and related terrorist groups are denied the most important facilities required in order to commit terrorist acts, namely funding, access to weapons, and the ability to travel freely. The United Nations Security Council has set up a sanction committee which must list individuals and entities who are part or linked to Al-Qaeda and Taliban member states of the United are obliged in terms of Chapter 7 of the United Nations Charter to give effect to the following in respect of individuals and entities to listed by means of enforcing in respect of such individuals, group, or entities. 1, assets freeze. 2, arms embargo. 3, travel ban. The Protection of Constitutional Democracy, Chairperson, Against Terrorists and Related Activities Act provides for the enforcement of these sanctions, publication in the Gazette of the proclamation made by the President, as well as parliamentary oversight, and the Security Council. And the Security Council has appointed an ombudsperson to investigate submission for delisting. The Select Committee on Security and Justice reports that it has concluded its deliberations on the proclamations made in terms of Section 25 of the Protection of Constitutional Democracy Against Terrorists and Related Activities Act, and recommends that the National Council of Provinces approved said proclamation. I thank you, sir.
Thank you. That concludes the debate. I shall now put the question. The question is that the report be agreed to. Honorable Labuskagan.
Honorable Chair, I raise on a point of order and action on a point of privilege. I request from the Chair that I withdrew the vote of the Western Cape on the previous order. Can I just... I have to vote in all the provinces in the program.
Honorable Labuskagan, sorry. Order, members. Let's allow Honorable Labuskagan to raise what is raised.
I will just explain. In the program, the orders was changed, and so I was busy here and looking at it, and I voted on the previous, on the constitutional one incorrectly. So I therefore withdrew the vote of the Western Cape for the previous one. Can I do so, please? I will not do a declaration. I will submit the declaration in writing. Thank you.
Order. Honorable Lassahan, you were referring to the third order.
Yes, Chair.
Can you take your seat so that I address it? Do we have any other province that is intending to do the same thing? No. Honorable members, I'm dealing with heads of delegation. Western Cape have decided that they've made a mistake. And no, you can't speak on behalf of Western Cape. Not unless you want to do something on behalf of Mpumalanga. Are you intending to withdraw on behalf of Mpumalanga? Or you have made a mistake? Yeah, so why are you standing?
On a point of order, Chairperson, it shows you that these provinces do not have mandates. They can chop and change here. They don't have mandates. Western Cape made a mistake with that mandate. If any other province can change now.
No. Can you take your seat? Honorable Julius, take your seat. Let me make a ruling. Take your seat, Honorable Tobejan. Let me make a ruling. In view of, in light of the correction that has been made by Western Cape, let me say 8 provinces voted in favor. I therefore declare the report as agreed to in terms of section 65 of the Constitution. It's not changing anything. Thank you, members. Koshi.
Chairperson, my point of order is in terms of procedure. You ask the House towards voting on the 4th item on your program. And instead of finishing that business, something jump in between. If I were to say to you, can you allow us to finish the 4th program? And if there's anything that you want to entertain with Western Cape, let it be entertained at that appropriate time. Can we finish this business on the 4th item?
Unfortunately, Honorable Tobejane, I've made the ruling. I've disposed order number 3. Now we're dealing with the 4th order. In accordance with Rule 7.1, I shall first allow provinces the opportunity to make declaration of vote if they so wish. We shall now proceed to the voting on the question. I shall do this in an alphabetical order per province. Eastern Cape.
Eastern Cape, iyayixhasa le ngxelo.
Free State.
Free State, Amoela, Chairperson.
Gauteng.
Gauteng agrees.
KwaZulu Natal.
KwaZulu Natal iyayixhasa.
Limpopo.
Limpopo yayitheha modulesti.
Mpumalanga.
Mpumalanga yasekela sihlalo.
Northern Cape.
Northern Cape agrees.
Northwest.
Northwest agrees, Chairperson.
Western Cape.
We agree on this one.
9 provinces voted in favor. I therefore declare the report as agreed to in terms of section 65 of the Constitution. The Secretary will read the 5th order of the day. Order, members.
Consideration of Financial Intelligence Center Amendment Bill, Bill 33B of 2015.
Let me invite the Honorable Chairperson of the Select Committee of Finance, Honorable De Pierre.
Honorable Chairperson, the Financial Intelligence Center Amendment Bill updates South Africa's anti-money laundering and combating of terrorism financing legislation so that it aligns with best practices and standards as set by the OECD, Financial Action Task Force, and the United Nations. The FICA bill also closes gaps identified by the FATF Mutual Evaluation on South Africa, conducted in 2009. Further, the FICA bill enables South Africa to effectively implement the United Nations Security Council resolutions relating to the freezing of assets and give effect to the Constitutional Court decision requiring that the FIC to obtain a search warrant for non-routine inspections. The FICA amendment bill also have the following objectives: to establish a stronger anti-money laundering and combating of a terrorism financing regulatory framework, to provide for the adoption of a risk-based approach to consumer due diligence, to align the country with international anti-money laundering and the combating of the financing of terrorism standards, we call it the CFT, to enhance customer due diligence of financial institutions, especially concerning domestic and foreign influential persons and beneficial owners, to provide for the implementations of the United Nations Security Council resolutions relating to the freezing of assets of persons suspected of financial crimes, to dissolve the Money Laundering Advisory Council by repealing and deleting Chapter 2 of the Municipal Act, to enhance the supervisory powers of the FIC and to enhance administrative and enforcement mechanisms within the Centre and other related institutions. Through amendments, the bill has extended the objectives of the FIC Act by adding that the FIC should make information collected by it available to the following organizations: the National Prosecuting Authority and Intelligence Service, the South African Revenue Service, the Independent Police Investigative Directorate, the Intelligence Division of the National Defence Force, a Special Investigation Unit, the Office of the Public Protector, an investigative division in an organ of state or a supervisory body. A number of subsections were inserted into the original Act. Chairperson, the bill will result in institutions, especially within the financial sector, increasing their vigilance and implementing risk management systems that will promote ethical behavior within the sector. Parliament has to receive a report at least once a year on the implementation of the bill. The Select Committee on Finance, having considered and examined the Financial Intelligence Centre Amendment Bill, B33B of 2015, National Assembly, Section 75, as referred to it and classified by the JTM as a Section 75 bill, reports the bill without amendments. Chairperson, I shall move.
Thank you. That concludes the debate. I shall now put the question. The question is that the bill be agreed to. In accordance with Rule 63, I shall first allow poll card parties to make their declaration of votes if they so wish. We shall now proceed to the voting on the question. Members will vote by pressing in favor, against, or abstain buttons. We can vote, members. Have all members voted? If any member have mistakenly pressed the incorrect button, please press the correct one. Can Honorable Moha, be? We do have those that are abstaining. I want to be sure. Let me confirm with Honorable Kaula and Honorable Engelbrecht. I don't want to assume it's the table, the machine is reflecting something here. Are you abstaining, Honorable Engelbrecht? You have voted? But it's showing that you haven't voted here. Honorable, can you, no, you can indicate in favor. Honorable Kaula, but can you indicate also, please? Thank you. 34 members voted in favor, no abstention, and no member voted against. The majority of members have voted in favor. I therefore declare the bill agreed to in terms of Section 75 of the Constitution. The Secretary will read the sixth order of the day.
Consideration of Performing Animals Protection Bill, Bill 9B of 2015, and report of Select Committee on Land and Mineral Resources thereon.
The Honorable Chairperson of the Select Committee on Land and Mineral Resources, Honorable Sifako.
Honorable Chair, Honorable Chief Whip, honorable members, distinguished guests, our learners. The future of South Africa is in your hands. Build it now. Report of the Select Committee on Land and Mineral Resources on the Performing Animal Protection Amendment Bill, B9B 2015. The historical background. Historically, the protections of animals in South Africa has been regulated by two acts, the Animal Protection Act of 1962 and the Performing Animal Protection Act of 1935. There is a general view across the sector that both pieces of legislations are old and require revision. The Principal Act has been for many years used in conjunction with animal protections. And these became the two main pieces of legislations that have been used in the country for many years to regulate the performing animals and the prevention of cruelty to animals. The administration of these acts was transferred from the Department of Justice to the Department of Agriculture in 1994. In 2012, the World Organization of Animal Health, also known as OIE, conducted an oversight visit on the performance of veterinary services in South Africa. At the end of the mission, with regard to animal welfare, the report indicated that the current legislation is outdated, not harmonized with OIE, welfare in the veterinary services. Constitutional Court ruling on the Performing Animals Protection Act. The following applications by the National Society for the Prevention of Cruelty to Animals to the Gauteng North High Court in 2012 regard Section 2 and 3 of the Performing Animal Protection Act, an order declaring section of the Act unconstitutional to the extent that they require a magistrate to issue animal training and exhibition licenses. The matter was referred to the Constitutional Court. At stake was the principles of separations of powers. The Constitutional Court on the 11th of July 2013 declared Section 2 and Section 3 of the Performing Animal Protection Act as unconstitutional. The Constitutional Court gave Parliament an order to remedy the defects in Performing Animal Protection Act within a given time framework. Section 2 and 3 provided for delegated powers to magistrates, granting them the authority to issue licenses for performing animal. That is, animal used in circuses, films, dog for safeguarding, for respective industry, and so forth and so forth. In declaring these sections unconstitutional, the court's finding was that the issuing of licenses is an administrative function that should be performed by the executive, not by the judiciary. The Constitutional Court judgment also ordered Parliament to remedy the defects within 18 months, alternatively by 10th of January 2015. From the date of the judgment, on the 27th of November 2014, the Constitutional Court granted an extension to the 12th of July 2015 at the request of the Department of Agriculture, Forestry and Fishery. Objects of the amendment bill. It is against this background that the Department of Agriculture, Forestry and Fishery in early 2015 tabled the Performing Animal Protections Amendment Bill to the Parliament. The amendment bill is aimed at regulating the exhibitions and training of performing animals and the use of dogs for safeguarding. The amendment bill seeks to amend the Performing Animal Protection Act of 1935 so as to repeal certain sections, provide for designations of national licensing officer, provide for a procedure for application for a license, provide for the functions of a national licensing officer, and to provide for an appeal process. The amendment bill proposes that the functions of issuing licenses previously performed by the magistrate are to be delegated to the provincial, state veterinary office or any office of the Department of Agriculture, Forestry and Fisheries with animal scientists in the same magisterial area. Future legislative requirements. What the amendment bill does is to deal with the consequences of the Constitutional Court judgment and corrects the violation of separations of power as contained in the Municipal Act. What this amendment bill does not do is to amend an outdated act, which is deficient of many aspects. While the existing legislation can be effective as far as specific cruelty to animals is concerned, but any action is largely dependent on information supplied by the members of the public and subsequent reaction from animal welfare organizations. This has reinforced the need for a complete revision of the animal welfare legislations to create appropriate, modern, and enforceable norms and standards for animal welfare, thereby dealing with the aforesaid gaps. The Select Committee looked forward to new consolidated and revised draft legislations dealing comprehensively with animal welfare. Processing of amendment bill by the Select Committee. The Select Committee considered the amendment bill on the 12th April, the 3rd May, and the 10th of May, respectively. On the 12th April, the department briefed the committee and discussed. And discussion revolved around the licensing process and the compliance, tagging, and the absolute nature of the Principles Act. The department confirmed that they are in a process in drafting new consolidated legislation. On the 3rd May, the committee, having advised for public comments, on the 3rd May, the committee, having advertised for public comments, received a submission in the form of comments, request.
Honorable Sfako, try to conclude.
And the comments were from the following: the South African mohair grower, cruelty to animal welfare, the wild ranging, the beauty without cruelty, the national fair, the South African Institute for Advanced Constitutional. The resolution of the committee, the report on the amendment bill was adopted without any amendment. Thank you, Honorable Chair.
Thank you. That concludes the debate. I shall now put the question. The question is that the bill be agreed to. In accordance with Rule 63, I shall first allow political parties to make their declaration of vote if they so wish. Honorable Smith.
Thank you, Chairperson. Can I stand from here or must I stand in front?
You can even come here, it's fine.
Honorable Kathy, I'm speaking to the South African public if you don't know your responsibility. Honorable Chairperson, as the Select Committee of the NCOP, our minor responsibility is to ensure that we scrutinize legislation to ensure that it has the relevant impact and is implementable. This has not happened with this piece of legislation. It was steamrolled through the committee in the last 30 minutes of a select committee meeting without properly considering each and every clause, like it happened within the National Assembly's Portfolio Committee, which I also attended. The Performing Animals Protection Amendment Bill, also known as the PAPA Bill, is a clear example of the lip service by the ANC government. This bill does not in any way improve the welfare of animals in its current form. It took the department forever to simply make a few amendments to comply with the judgment by the court. Instead, it is the Performing Animals Protection Act 24 of 1935 that is outdated. This bill should be scrapped and redrafted as indicated by the department as well. This farce of a bill has amounted to fruitless and wasteful expenditure, as it has to be overdone in any way after this. The DA opposed this bill in its current form. I thank you.
Thank you. Any other political party? ANC?
Thank you, Honorable House Chair. As the ANC, we support this bill. It is not true that this bill was streamrolled. It was introduced. We had a 3-week period that we dealt with this particular bill. We were briefed by the Department of Agriculture, Forestry and Fisheries. We had a legal representative of Parliament being present, as well as legal representative of the department and the state law advisor. So the only thing that the DA questioned was why it was not tagged as Section 76. Everybody else was happy with the presentation. Nobody opposed what Honorable Smith is saying. He never said it in the committee. Both of us are in the same committee. This is as a result of the constitutional decision that the current bill or the current act is unconstitutional in that it was being administered by the then Department of Justice. And therefore it was decided by the Constitutional Court that this must then go to the executive. It should not be administered by the courts. And there was a time frame. There was a time frame that was given by the Constitutional Court that we need to meet. We are out of that time frame. We had to ask for extension. That extension was granted until August. So it is important, because all of us are not going to be here between now and August. It is important that this House must adopt this particular bill today, because we won't be in line with the court decision if we don't adopt it today. So that is why, Honorable Chairperson, as the ANC, we support this particular bill. Thank you.
Thank you. Any other political party? In accord, we shall now proceed to the voting. Honorable Smith? Order, members.
Thank you, Honorable Chair. I'm sure we're all familiar with the rules of this House, as this is a Section 75 bill. We are 54 permanent members within this House. So to conclude a quorum, we need 27 members plus 1. And if I'm counting quickly, I'm standing around 26 members currently in the House. So if you can just clear us on that matter. Thank you, Honorable Chair.
Order, members. Order, members. Let me, Honorable Mr. Falco, allow me to make a ruling. Okay. There's a point of order raised by Honorable Smith. Honorable Smith, Honorable Smith, I'm addressing your point of order. If you go to section 75(2) of the Constitution, I'll read it for you. If you have a copy, section 75, subsection 2, when the National Council of Provinces vote on a question in terms of this section, the 65 does not apply. Instead, A, each delegate in a provincial delegation has one vote. B, at least 1/3 of the delegates must be present before a vote may be taken on a question. At least 1/3. We have 54 members here, and 1/3, it's 18. So I've addressed your point of order. Honorable Mohapi, it's another point of order.
Yes, Chairperson, can the honorable member apologize to the House for misleading the House, honestly, and the public at large?
No, in terms of no, other members, I'm addressing the point that is being raised. It's very important by Honorable Mohab. In terms of, I've made the ruling using the Constitution to guide us that he was under the wrong guidance. So I've assisted him. So let's leave it to him. Let's go on to the voting. We shall now proceed to the voting on the question. Members will vote by pressing in favor, against, or abstain buttons. Honorable Madikhale.
Thank you, Chairperson, for giving me an opportunity. I just want to check if ever it's parliamentary for the Honorable Smith to be ignorant.
Honorable members, once we get to the part of voting, we're not entertaining any point of order. Let's get to the voting. Honorable members who are voting now. Have all members voted? Who are voting, honorable members? Have all members voted? Honorable members, 25 members voted in favor, 1 against. The majority of members have voted in favor. I therefore declare the bill as agreed to in terms of Section 75 of the Constitution. Honorable Mohapi.
Chairperson, can I make a request that Honorable Smith should call those members to come back at least? The job is done.
Honorable members, Honorable Makua.
Chair, on a point of clarification, if you have egg on your face, does it make you red?
Honorable Smith.
Honorable House Chair, I'm taking great offense by the honourable member. But beyond that, I also want a point of clarity here. In terms of that specific point in the Constitution, does it apply? No, does it apply to the full House? Because special delegates can also vote here. So then it should be a third of the full House. And it should be a third of the full House. Talking about egg on the face.
No, honorable members, it's still entitled to seek clarity. But Honorable Smith, as you have the copy of the Constitution, and you can be assisted to understand it further, because we are not going to subject it to the discussion. We are done with it. That concludes the business of the day. Honorable members, you are requested to remain standing in your places until the procession has left the House. The House is adjourned. Thank you.